Okay, hello. So today we are gonna discuss about Keshwanand Bharati versus the state of Kerala. So this complete series is about some of the landmark judgment of Supreme Court, and this particular case is a very interesting case. Not because of you know of the year or in which it is, but because it's all about rights which it's talk about. It's talk about that from how much power does the parliament have? Does the parliament have power to make the changes into the constitution which can take away the fundamental rights which is enshrined in the constitution? So this case is one of the landmark judgment, and any students of law, anyone who knows about or read about the law have surely understood and have heard about at least about what the Keshwanand Bharati case is, and because of the impact which has made. Okay, so to understand this Keshwanand Bharati case, it's important to understand the characters which is involved into all these things. So first character is Keshwanand Bharati. So it would not be wrong to say Your Holiness, or because he was a Sankaracharya who was heading the Adnir Mutt. This is the mutt which is in Kerala, and he have a lands and where he uh, grow, through which the income which is get generated is being used to manage the different activities of the mutt. And what happened that Kerala government bring up a new law, which is the land reform law, under which some of the lands of this mutt was taken away, and because of this, it become difficult for the mutt to make it functioning, do it functioning. So Keshwanand Bharti got suggested from some of the lawyers that they can approach to Supreme Court uh, to for their rights. So they filed a petition under Article 26 saying that they should be having a freedom to manage religious affair. That's what Article 26 enshrine. And concerning the right about the managing religiously owned property without governing government interference. So that's what is being enshrined in Article 26. And for that, Keshwanand Bharati approached Supreme Court. And in the starting, the very prominent lawyer at that point of time was Nambiar, who introduces him to Nani Palikiwala. And because this case is also seen as a, such an important case and always being referred by the lawyers and admired by them because the way the Nani Palikiwala have pursued this case in Supreme Court. So, because this new amendment which Kerala government was bringing become a part of the constitution uh, by 929th Amendment Act, because any of the such amendment requires to get put into the constitution under the ninth schedule, which is being said that under the power which is provided in Article 31A. So that's why this is a constitutional amendment, and this constitutional amendment was placed in when put forward in 1972 and passed through parliament. Then that become a problem, and the constitutionality of it was questioned. And from the perspective that does Article 368 is the article in the constitution which provides the power to the parliament to create any law, or they can change anything into the constitution, because that's what is being said into it. But at the same time, in Article 32, which is a part of Part 3, said that state cannot make any law which can take away the rights which is provided into the Part 3 of the Constitution. okay, or any of the law which takes away the rights which is provided in part 3 of the constitution is void if it's contravenes to it. So there's a two contradictory articles which was in the in the constitution, and the question comes that which what supersedes others, like whether article 360 have 8 provides the parliament that much power, or article 32 restricts them to do such thing. So what happened was, just a minute. Yeah, sorry. So judgment. So this particular judgment which was given by the Supreme Court, it marks the foundation for the judiciary power to review and strike down any amendment which is happening to the constitution. Okay, but this complete thoughts around that with power of constitution, this was not the first case where this was discussed. Okay, so there is a good to know the history a little bit, right? That in the 1951, in 1950 we got our constitution. There was a case of Sankari Prasad versus Union of India. There also something similar happened. Like, does the question came up in the front of Supreme Court? Does Article 368 provides the ability for the Constitution to make the amendment into the fundamental rights? So in that, during that time, Supreme Court upheld that 368 provides the power to change anything into the Constitution. So if the Parliament wants, they can change or take away all the fundamental rights, whatever is available in Part 3 of the Constitution, because it's being said that Article 13(2) talks about law, and this law is basically the ordinary law. It's not covers the amendment which is happening into the Constitution. So that's the basic difference which Supreme Court interpreted at that point of time. Later Sanjay Singh versus State of Rajasthan happened, which was in 1964, where again it upholds the Sankari Prasad, even though there are a few judges who have the opinion contrary to it. Then Golaknath versus State of Punjab happened in 1967, where Parliament said that again the ruling was that the Parliament could not curtail any fundamental rights in the Constitution. That the Parliament have a restriction which is on the power which is provided under Article 368, that they cannot curtail the fundamental rights in the Constitution. So to overcome this Golaknath judgment, several amendment was made under 24th Amendment Act, so that government can find out the way to make a changes the way they want to. Okay, and then in 1973, this case Keshwananda Bharati versus the state of Kerala happened, where the basic structure doctrine was established, where it has been said that Parliament have the power to change anything, but not the basic structure. Okay, so but one thing is to be seen that this when we say that they can change anything but not the basic structure, but definition of basic structure was not defined, but few of the examples was given during this period of time, like they cannot change the republic or democratic form of government, secular nature, or separation of power between legislature, executive, judiciary, or federal structure. So these are the things are the basic of it. So those cannot be changed away, right? So that is what was said in this judgment, and it's very it's also important to know that it was a 13-judge bench which decided this case by 7-6 verdict, and so it's a very sharply divided verdict. And at that point of time, only 13 judges were there in the Supreme Court, and all of them were on that bench. So if you think from that perspective, if in the future, if government wants to alter these fundamental rights, then it requires at least more than 13 judges bench to decide to overrule this particular judgment. So this ensures that our fundamental rights or our fundamental basic principle which is provided to us cannot be taken away by the parliament by passing any amendment or any law. So that's why this is called as such a landmark judgment. And Supreme Court said that Constitution is not the gate but the road. It cannot stand still but move on. That life of a progressive nation as of an individual. So because Constitution is not a still thing, it evolves. Hence, from if you have seen that from the judgment which happens earlier from the Sankri Prasad to Keshwanand Bharati, the Supreme Court also evolve its own interpretation of the Constitution, and now it ensures in the Keshwanand Bharati case that basic structure doctrine, and those are the crux of soul of our Constitution. Parliament cannot take it that away. I hope that you got a you know crux of what this case is, and from how we got the rights which we have today, and how it all ensured, and how Supreme Court uphold these rights. So do let me know if you have any question. Please comment and share your views. Thank you.